All rise. The Court of Appeals, Division 1, is now in session.
Morning, please be seated. This is the time set for oral argument in the case of Mortensen versus Mortensen. Our civil number 15-0097. Each side will have 20 minutes within which to make their arguments here this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. We have reviewed the briefs. We've been through the record. We conferenced this case this morning, so we're familiar with the underlying facts and the issues that have been raised by the parties. We are recording these proceedings, so as you approach the podium, please identify yourself and your client so we can keep track of that. And if you're really interested, in a few weeks, the audio recording, or video recording, I guess, will be posted on YouTube for your viewing enjoyment. With that, counsel for appellant may proceed.
May it please the Court. My name is Taylor Young, and I represent Barbara Mortensen in this appeal. Barbara Mortensen is entitled to a new trial in this matter because of 3 errors that were committed below that substantially prejudiced her. First, she was deprived of her right of due process when the trial court refused to continue the case to allow her to cross-examine husband in this matter regarding issues of assets that were being divided and also spousal maintenance issues. She was also deprived of the opportunity to present her own direct testimony to the court. So in this case, what we had was a trial judge who had allocated 3 hours to this hearing and refused to give her additional time so that she could take the stand on her own behalf and so that she could cross-examine husband in this matter.
Now, I was a little curious about this, Mr. Young. Ms. Mortensen was the petitioner below.
Correct.
Why didn't she start her case by testifying herself and calling her husband for cross-examination, as opposed to calling these other witnesses?
Well, the critical issue in the case was how are we going to value the main marital asset, right, which was Canyon State Drywall. It's the couple's business that they had had for the majority of their marriage. There was a huge dispute about the value of that business. As the court's aware, the evaluation came down, valuing it at 0. Ms. Mortensen had a different opinion, which was that it was $1.2 million, and that difference was critical. So the decision was made to start off the case by presenting this expert testimony. Now, the trial court recognized that we might need more time in this case. The court even talked to the parties about dates that would be available for a 2-hour continuation. And yet, at the end of the hearing, the court didn't grant that continuation. Instead, what the court said was, we're done. You can present written closing arguments. And then Ms. Mortensen's counsel had to try and wedge something in there and essentially got a concession that he could provide an affidavit from his client, which, of course, is not a substitute for her own live direct testimony when credibility is an issue. And you can't obviously cross-examine an adverse witness by affidavit. So,
counsel, did your client then call Mr. Mortensen to the stand to state his position first? How did he follow up the experts?
The sequence of events was that it was I think that if I recall correctly, and I wasn't trial counsel, I know you guys hate that, but I wasn't. Mr. Ellsworth might have a crisper recollection of that. But I think we went out of order in this case to deal with the expert testimony first, and then husband presented his direct because we were out of time. Under an allocation of time, each side gets 1.5 hours of 3 hours, that sort of thing.
So you had used all your time, and husband still had some time left.
Most of the time was used on the expert testimony. That's correct. But again, it's not a rigid rule, as this court knows. There isn't a rigid time limits are disfavored, and in this instance, what we had to do was present our expert. And there had been a motion in limine. That motion in limine was sort of quasi-reserved, ruled upon, and then the court granted a continuing objection to our expert's testimony, and that's what took over the hearing. But this isn't a case where there was inefficiency. This isn't a case like Krenzen v. Katz, which is an unpublished decision we cited in our reply brief, which Judge Norris was on that panel, in which many of the arguments were about, did you use your time appropriately? And there had been lots of admonitions from the judge about how time ought to be used. That doesn't appear in this record. So in this instance, this is a case where the court had already identified a date, had already identified a couple more, for 2 more hours. I don't think 2 hours would have been necessary. And yet, at the end of the day, what the court said was, nope, we're not going to have cross-examination of husband, and we're not going to allow wife to testify on direct at all.
Mr. Young, let me ask you the following. Let's say that based on your arguments and the arguments of the other side and our review of the record, we end up agreeing with you that the court should have granted a continuance to allow your client to testify and to cross-examine Mr. Mortensen. Then the question is the scope of the remand. Looking at Mrs. Mortensen's affidavit and considering it as a form of offer of proof, it seemed to me that she clearly provided information that would be pertinent to contesting spousal maintenance. But I can't say in reviewing it that there was much in there, if anything at all, about the credit card debt and the allocation of the vehicles. And so if we were to agree with you, what other than spousal maintenance, why would we want to remand for anything else?
Well, I think that clearly spousal maintenance is the...
And put aside the business valuation for a moment, but on these other ancillary issues.
Sure. Well, so with respect to the ancillary issues, I think that a remand would still be appropriate given that we were denied an opportunity to cross-examine Mr. Mortensen on those matters.
But I don't see any argument really in her affidavit or anything, and even in the appellate brief, other than she didn't particularly like what the court did, that would provide at least me some principled way to say, yeah, there's more to be said about allocation of the 2 or 3 credit card, because she agreed to accept some of the credit card debt, and the court assigns the debt that she had accepted to her. And on the cars, she got the Lexus and he got the crew cab.
Well, so I think in terms of the remand, what my concern would be is if we remand it for spousal maintenance, obviously a spousal maintenance consideration has to consider all the other issues. It has to consider whether or not property has been awarded that will be sufficient for a wife to, provide for her own needs, those sort of things. And so I think that there is a potential for intertwining when you're talking about dividing up property and debt, that limiting the remand could be problematic about. Does that make sense, Your Honor?
Well, I think I understand your point, yeah.
Yeah, so that's my point. Am I standing here telling you that the cars and the credit card debt are why we're still litigating this case?
I don't think so.
No. So I'm happy to talk about the due process violation, but I'd like to move on to the expert and Daubert issues. So the other reason why we're entitled to a new trial in this case is that the trial court excluded the opinion testimony of our expert, an expert who we think meets all the qualifications under Daubert and whose opinion met all the qualifications under Daubert. The other side makes a lot of noise about how there were problems with his opinion. With his opinion regarding things that Mr. Coons had done and with including certain things or not. But what their argument really boils down to is because this is a calculation of value as opposed to a opinion of value under the standards, it's essentially per se inadmissible under Daubert. And I've yet to find a case that actually stands for that proposition. I would think that there would be one, but I don't think that there is one. I think that the way to challenge Mr. Hughes' calculation of value is to do exactly what happened in this case, which is to subject him to vigorous cross-examination, point out to the trier of fact the limits of the engagement that he was involved in, but there's nothing that renders that so inherently unreliable that it can't be admitted in court under the Rule 702 standard.
On that question, let's say we agree that the court should not have excluded the calculation of value by Mr. Hughes under Daubert and Evidence Rule 702. Yet the court sits as the finder of fact, and the judge made some pretty critical comments in its minute entry about Mr. Hughes's methodology and opinion. And he could have then said, okay, this goes to the weight, and I'm not really attaching any weight to it because Mr. Hughes, for example, only relied on 10 months of unaudited financials and the like. So when you get right down to it, is it kind of a no harm, no foul?
I don't think it's no harm, no foul, and let me tell you why. We don't have that ruling. We don't have a ruling in the alternative that says his opinion doesn't meet the Daubert standard, so under my gatekeeping function, keeping the gate for myself as the trier of fact, I am going to rule that he doesn't meet Daubert. In the alternative, I would give it no weight. He doesn't say that. We don't have that ruling here. And in fact, after the initial decree, we have a subsequent ruling where the court makes it very clear that his ruling is that he doesn't meet it, that this doesn't meet the Daubert standards. Now, he does make some comments about wife having hired a less qualified expert, which, okay. You've seen Mr. Hughes' CV, but nonetheless, he's doing that in the context of Daubert. And I don't think that this court can just presume that what the court would have done is then said, I'm going to consider the testimony but give it zero weight. If there was that kind of finding, then we'd have a different circumstance, but there isn't.
Well, but for example, and I'm paraphrasing, the trial judge commented about, I think that Mr. Hughes's method was not as complete. I think that's maybe the word he used. And so looking at the record, when Mr. Hughes relied on only 10 months of unaudited financial statements and didn't make any comparison to prior years, and Mr. Coons criticized that, so there's evidence from another competing expert that that's not complete, that's not reliable. Although I hear you loud and clear in the argument you're making, it still strikes me that the judge could easily have said, you know, Daubert, yes, Daubert, no, but I just don't find him.
No, I understand what the court is saying. I think there's a couple of pieces of that. First of all, the unaudited, 10 months unaudited financial statements, those are what were available, and that gets to the other issue in our case, which is why this is such a prejudicial error, which is the valuation date. That we have a valuation here that is done as of the lowest point in the construction bust, valuing this company at zero, and a trial that's happening 20 months later.
But Ms. Mortensen stipulated that the court-appointed expert, both sides did, would value the business as of December 31, I think it was 2011.
And that was when the trial was going to happen.
But I don't see anywhere later that there was for example, I don't see a motion by Ms. Mortensen to the court saying, passage of time, we need to revisit the valuation date. I don't see a motion on that anywhere in the record. Or, for example, why not just call up Mr. Coons and say, will you supplement your opinion of value, and we'll go ahead and pay you for it?
Well, Your Honor, let me respond to both of those things. There is an argument about updating the valuation in our response to the motion in limine.
Yeah, but that's not a request to say, Judge, we need to have now a new valuation or an updated valuation. There's no affirmative motion. There's an objection.
Correct.
Right.
Okay. And obviously we then did not only had an expert who prepared an updated valuation, we sought to present it at the hearing. So I think that's an issue that was a request, at least, was maybe even tried by consent. I mean, I don't think that there is, that you can say this is an issue that we completely waived. In fact, we sought to get an update.
I'm not suggesting that.
I hear you. I hear what you're saying, Your Honor. In response to asking Mr. Coons to provide an updated valuation.
I know there's the emails and, yeah.
There's the emails. There's also a reference in that response to the motion in limine that says that both sides have made this request. That contention has never been rebutted by the other side. They've never said, no, we didn't make a request. What they've said is they don't know why we didn't pay Mr. Coons to do this additional work. I wish I could tell you that I have something else in the record that I could point you to about that request, but that's all I can say on that issue. I would like to reserve the rest of my time for rebuttal unless the court has specific questions.
Oh, thank you, Mr. Young.
Morning, Your Honor. Steve Ellsworth, representing the appellee, Jerry Mortensen, in this matter. Judge, let's start, first of all, I do have the perspective of having been the trial judge. I've lived this case. I've been with it from day one since it was filed in 2011. I want to talk about the due process argument first. This case the trial was continued 9 times during the course of the pendency of the case. The last time it was continued, Mr. Delgado, the attorney, was ill and called me up, asked for a continuance. I agreed. We got on the phone, and here's the critical point. Opposing counsel makes an argument about the trial setting, how it was 6 hours, and it was 5 hours, and it was 4 hours, and it was 3 hours. When this trial was reset for August of 2013, it was set by Mr. Delgado and I getting on the phone with Judge Ryan's judicial assistant, selecting the date, and telling her how long we needed for trial. And that's in the record. I put it on the record at the end, judges, that's what happened. So my point is that Mr. Delgado and I talked to the court to reset it. We told them we needed 3 hours to do the trial because we had a lot of agreements in our pretrial statement that had already been prepared. So it was by agreement that we agreed to a 3-hour trial. This was not a cram down where Judge Ryan said, I'm giving you 3 hours for trial, take it or leave it. It's not like the Volt case where they said you got 15 minutes and that's it. Now, when we get a time limit as trial judges, how we use our time is up to us. We have to manage our time effectively. In this case, Ms. Mortensen was the petitioner, so she went first. She could have testified first. She could have called my client as a witness. They chose to call their expert, Mr. Hughes, and they spent a significant amount of time on Mr. Hughes in direct testimony. At the beginning of the trial, in the record, I'm a trial attorney, and what I find usually is that when you're second, you get shorted on time in trial. And so on the record, page 10 of the record of the trial, line 23, I said to the judge, timing-wise, I want to make sure we're going from 9 to 12. I was confirming the 3-hour trial. The court said yes. And then I said, and honestly, Judge, the person who goes second often gets shortchanged, so I want to make sure that the time is equally divided. And Judge Ryan said, I will do my best. So he was going to divide the time between us. How wife chose to use her time was totally up to her and her counsel. And they mismanaged their time is what happened. After,
You know, I've read the transcript, and this is, you're right, this is not a cram down, as in vote or vote.
Right.
Yeah. But having looked at this, and yeah, maybe they should have started with Mrs. Mortensen first, but it's, again, looking at a code record, it appeared that both sides used the times prudently. They asked pertinent questions. They were not going down bunny trails. Mr. Mortensen was allowed to testify. They just you ran out of time. And at that point, there was, what was the, other than the fact that it was to your client's advantage not to have any testimony from Mrs. Mortensen or to have your client cross-examine, what prejudice would have been to grant a couple additional hours? And the court even alluded to the fact they had a couple additional hours in early December or November, something like that.
Yeah, and let's be clear, because the statement that counsel made, he said that the issue of continuing it and 2 hours of additional time was brought up at the beginning of the trial.
No,
that wasn't
but
the case.
I know it wasn't.
It was at the
later.
end when
Right.
we got to this point. At that point, I think the issue was, Judge, that we wanted finality. We'd been going for 2 years. It had been continued 9 times. We both knew what time we had going into trial. We both knew what the parameters were. I used my time efficiently, and I had my client testify. I could have, as lawyers, if you give us 3 hours, we'll take 3 hours. If you give us a day, we'll take a day. We expand and contract our case based on the time. So at that point in time, the judge talked about a continuance. He talked about some time in December where it could be continued 3 months later. And then he brought up, and I think this is important for the court, he brought up an issue and said, he gave an alternative. And he said, as an alternative, and this is in the record on page 129, I'm sorry, 128, Judge Ryan said, look, I'm going to have you do closing arguments with your cross-examination and reference the exhibits. He said, how much time do you think that you need? This is page 128 of the record. And then he said, I'm not trying to talk you out of your wanting to continue. I'm just trying to figure out if that's the plan B that I do. What would be reasonable deadline to have the court, to have that committed to the court? Then Mr. Delgado said, you're talking about closing arguments. At this point, Mr. Delgado did not object at all to this other alternative. He didn't say, Judge, doing this is going to deprive my client. Judge, if you go with Plan B, she's not going to be allowed to present her testimony. He said on page 129, my concern, Your Honor, is would my client be allowed to testify via affidavit, at least to discuss the relevancy of spousal maintenance. We'd had a discussion that, again, in the pretrial, most of the other issues about property was agreed to. They were not contested. And at that point, the judge said, that's my point. He's going to allow you to submit evidence through a closing argument. My point there, Your Honor, is that Mr. Delgado at that point could have again objected and said this is not a good alternative, this is not a viable result. He didn't. The court then issued a minute entry, and in the minute entry, the court opted to deny the motion to continue, said that we should submit closing arguments, and then Mr. Delgado files not an objection, he doesn't object to it, he doesn't file a special action, he files an expedited motion to clarify, saying, Judge, I want to remind you that you said I could submit an affidavit, and I want to make sure that I can submit my client's testimony by affidavit. He asked the court to do that, to clarify the minute entry. Judge Ryan then issued a minute entry on 9/11/2013, saying that wife would be permitted to submit an affidavit, no affidavits from anyone else. So, Judge, and I go back to the Volt case, just as an example. In there, this court said, we don't substitute our judgment for the trial judge as far as the management of calendar and the time of the case, and went on to say that the court has broad discretion to impose reasonable time limits on proceedings. You also made a comment in that case, this court, that if somebody mismanages their time, they can't then come back to the court and scream due process because they didn't use their time wisely. I'm paraphrasing.
Counsel, who
Yes.
was the first witness?
The first witness was Mr. Hughes.
How long was he on the stand?
I have the record here, Judge. I can't tell you exactly.
Well, if
You'll give me a
you had
minute?
If you had 3 hours, what percentage of that time do you think Mr. Hughes took?
He probably took an hour, I'm guessing, Judge.
Okay, so then Mr. Coons was called to the stand?
Yes.
How long did he take?
I think he took less than that, Judge, but I can't tell you exactly without looking at the record.
So by then, about an hour and 45 minutes maybe was used up?
Yeah.
And then Appelli was called to the stand?
Then I called my client. At that point, when Mr. Delgado finished with cross-examination of my expert, Mr. Coons, the court in the record states that he'd used up his time. Let me refer you to the page there, Judge. Page 92 of the record, Judge Ryan said, "Counsel, by my calculations, even if I give Mr. Ellsworth the balance of the time, he still has 5 minutes less than Mr. Delgado. So even with giving me the remainder of the time, I still got less time than Mr. Delgado did."
So there was an hour and 45 minutes, and an hour and a half of that had already been attributed to the appellant? Is that the way that works? I mean, it's a 3-hour total.
Yeah,
So an hour and a half goes to each.
right.
And the appellant had already used up their time by the
Right.
time you called. So that out of an hour and 45 minutes, an hour and a half had been used by the appellant, and 15 minutes had been used by you.
That would be right, Judge.
So then you were able to use the next hour and 15 minutes with the appellee?
Well, Judge, and I'm going to go back and look here. I don't think I had an hour and 15 minutes with my client. It was very short. It was probably a half an hour because I went through his testimony very quickly.
Okay. Thank you.
The brunt of the time was used on the two experts, there's no question, mostly by Mr. Delgado.
All right, thank you.
Your Honor, but back to the due process, and I'm not going to spend all the time on here, though, but my point is that he had an opportunity when we set the trial to file and ask for more time. He had an opportunity before the trial, knowing what we were going to bring in, to file a motion to enlarge the time. They didn't. They had an opportunity at the beginning of the trial to ask for more time. They didn't. It was only after they mismanaged their time at the trial that they now asked for a continuance. And then this issue about submitting affidavits, that was something that he asked the court to clarify, and he could have objected then, and he didn't. So he was allowed to submit his client's testimony by affidavit. I couldn't cross-examine him. It was submitted unrefuted, and now they come and ask the court for relief. And what they're asking for, Judge, let's be clear, she wants a complete do-over of the trial. This is not a limited thing. They've thrown 2 or 3 arguments trying to see which one sticks against the wall. I'll shift now to the expert. The court, we filed a motion in limine on the expert, and the difference here is significant from a trial standpoint. An opinion of value versus a calculation of value. This was not apples versus apples. And Judge Ryan on the motion in limine, said, I'm going to take testimony first, in essence having a Daubert hearing as part of the trial to decide whether or not to exclude this evidence. And after he heard the evidence that was given, he found that Mr. Hughes, not his personal qualifications. Mark Hughes is a qualified business evaluator. I have been involved with him many, many times. The issue is not his personal qualifications. The issue was what he was retained to provide to the court. And if you look in the record, and it's in my brief, I asked Mr. Hughes when he was on the stand, whether or not, page 31 of my brief, it's in the record, I said to Mr. Hughes, and you indicate that you were retained to perform a calculation of the fair value, correct? Hughes said, that's correct. And I said, not an opinion of value, not a full appraisal of the company, correct? And he answered, that is correct. He was not retained, did not perform a full appraisal of Canyon State Drywall.
What page in the transcript is that?
39, lines 17 to 22, and 42, line 13 to 16. Then I asked Mr. Hughes, and this is critical, can you give an opinion of value pursuant to the standards of the AICPA as to Canyon State Drywall as you sit here today? And his answer was, no, I cannot.
Well, he wasn't engaged to do an opinion of value. I mean, there's no dispute. He was not hired to do that.
Correct.
He was hired or retained to give a calculation of value, which is a more limited form
Correct.
of valuation. So, I mean, we know that.
All
So, of course, he's going to say he was very candid on this. And I think the question goes, as Mr. Young was saying, is the various credentialing agencies recognize that a calculation of value is a legitimate engagement. It has, I mean, there's nothing that makes it, I didn't see anything in any of the literature or anything that's been filed in this case that suggests that it is per se inadmissible or unreliable. It is much more, it is more limited. It does not have all of the procedural complexities that a traditional opinion of value would have. But your argument is basically, per se, the court should have just thrown it out, and I don't see any substantiation anywhere for that. It comes down to, in my view at least, to the weight a judge should give it.
Well, and I don't think there's any case law in Arizona that addresses that issue, Judge, so I agree with you. It's maybe an issue of first impression that hasn't been ruled on. The problem with the calculation of value is the appellant decided what data was reviewed, what was considered. That's why there was 10 months of unaudited statements, and they didn't look at everything. And so it doesn't provide a legitimate view of the company, and that was the questioning that I did in the record that's in the brief, where Mr. Hughes testified that he never spoke to husband, he never went to the business location and inspected it, he never spoke to the bookkeeper for Canyon State Drywall, he never spoke to the accountant for the company, he didn't do any of the due diligence or background work that's necessary to do an evaluation. And I would say even if he's doing a calculation of value, he didn't do his basics that needed to be done. Judge Ryan then decided that based on all of this, that there wasn't enough here to find that he had done an admissible report under Daubert. It didn't meet that standard. So I think it was not just the calculation of value aspect, but because of the testimony that was brought out about all the things that he didn't do and all the things he didn't look at, that is part of what Judge Ryan did when he decided that it didn't meet the standard for Daubert. It wasn't just as simple as, oh, there's an opinion of value and a calculation of value. If that were it, he would have made that ruling right at the beginning of the trial. He said, no, I want to hear evidence first. I want to find out what he did. I want to find out what happened. So I do think that's a significant difference for your honors when you're looking at that. There was testimony that was also given by Mr. Coons about assumptions that were made by Mark Hughes in his calculation of value. And a big one was the profit margin for the company. Mark Hughes in his report said that the gross profit margin was 21.5%. He never talked to, again, husband. He never talked to the accountant. He never did anything. And had he done that, Mr. Coons said that they never did 21.5%, even in the heyday. It was 17% or 17.5%. So there were numerous flaws in the methodology that Mr. Hughes used that was, again, that's the basis, that whole package is why Judge Ryan denied the admission of his report and used or granted my motion in limine. It wasn't just the calculation of value. On the spousal maintenance, Judge Ryan used his discretion on the spousal maintenance. He had information from wife about what she was wanting. He had information about her income. In fact, in her affidavit, she acknowledged that she was receiving rental income. She acknowledged that she had received money from the sale of assets of Contagious, the other business. Their argument essentially on the spousal maintenance is flawed. One is that they cite Gutierrez to state that the court is mandated to award indefinite spousal when there's an unlikeliness that independence is going to be achieved. I would submit to you that's not what Gutierrez stands for. And two, he states in here in his brief that, well, they cite the spousal maintenance guidelines, which were never adopted by the Supreme Court and were rejected by the trial court in 2010. But he makes some different arguments that the court didn't consider all the factors. Judge Ryan, in his ruling, has broad discretion, as the court knows, to decide spousal. He considered everything, and he entered an appropriate order. And he did it based on the facts that were present, from the income from father, the income from mother, and what her expenses were. On the issue of attorney's fees, Judge Ryan made findings that attorney's fees were appropriate. He did it in the decree. He did it in the post-trial motion. One thing I think it's important for the court to note, Judge Ryan made some specific findings, and the specific findings that he made were, this is in the record, trial record 104, page 104. I'm sorry, index of the record 104, number 6. The court finds that the wife has acted unreasonably in prolonging and protracting litigation beyond all sense and reason. And then later the court, in December 18th, 2014, post-trial minute entry, says the court recalls that wife made it known that it was her intent to make this litigation as protracted and costly as possible. This has been the theme of the pattern and practice, and the court finds much of the litigation unwarranted, redundant, and calculated to increase husband's litigation costs. Judge Ryan made rulings based on the evidence, based on for attorney's fees. Their argument that because he didn't cite ARS 25324 in his ruling, there's only one basis to get attorney's fees in family court. It's ARS 25324. There's not a smorgasbord of statutes that we look at. We have one. That's it. So when he says in there they found that she was unreasonable, and in the pretrial statements we had both asked for fees based on 25324, that's not an error that warrants a reversal or a remand to the trial court. Again, I want to just close with, this is her request to get a second bite at the apple. That's what this is all about, not about errors by the court. Thank you.
Thank you. Mr. Young?
I'd like to clarify just a couple of issues. I think, Judge Jones, you've asked me and opposing counsel about the sequence of witnesses. In this case, what happened was Mr. Hughes was called by wife as her expert, and then wife then proceeded on direct to take Mr. Kuhn's testimony. And so the expert testimony ended up taking up the first half of this trial day, but it was both experts, and as the court's already noted, and that Mr. Kuhn's was hired by both sides originally. So in terms of the expert testimony, since wife went first, she presented the expert evidence from both. And so that's really what I think created an imbalance in terms of the allocation of time. I often, as an appellate lawyer, I often talk about being a Monday morning quarterback, and I could say what should have been done better, but I can't say that I would have done it better if I had been in those circumstances. Let me point out really briefly regarding the calculation of value and the court's consideration of weight. Again, I want to reiterate that there's nothing in the record that this judge made any determination regarding weight. His ruling is very clearly Daubert based. And with respect to Mr. Hughes' calculation, as we point out in the reply brief, he used 3 different methodologies in supporting his valuation. He used 2 that were expressly in his opinion, and then he did a 3rd to validate it. And so all of those, none of those specific methods have been critiqued by the other side. The entire critique here is that it was possible that what could have happened here is under a calculation of value that the client could have controlled and manipulated the expert in some way. But on balance, when you read the expert's testimony, there's no evidence that that happened.
Do you happen to know whether, or the record contains the engagement letters for Mr. Hughes and Mr. Coons?
I believe it does. I think that the engagements are part of their reports, but I'd have to take a look.
Well, I didn't see them as appendices to
In the
report,
appendix, but
we'll take another.
they may have been exhibits. The other thing that I wanted to mention regarding the attorney's fees, there are other statutes upon which you can get attorney's fees. You can be a vexatious litigant. There's other things. Just because in family court we often are looking at this statute doesn't mean that it's the only statute that's available. And the court's ruling that wives taken unreasonable positions, in our reply brief we address each of those positions, and we explain that in the post-decree proceedings we moved for affirmative relief once and won. We got a garnishment of the spousal maintenance arrearage. Everything else, we were simply responding to what the other side was doing. The court also seems to have taken a little umbrage with us for making some argument regarding Canyon State Drywall and the ownership of Canyon State Drywall. That was particularly perplexing for us because Canyon State Drywall was not awarded in the decree. The other side sought to amend to have it awarded to them. We suggested we didn't think that that was a good idea. The court then issued a ruling in May in which it said that it had intended to award Canyon State Drywall to husband, but that it wasn't going to deprive wife of her community interest in Canyon State Drywall until husband became current on his spousal maintenance arrearage. The court then later tells us that what he had intended by that was that we should have known that what he meant was that he was speaking of a lien, that wife had a community lien or a lien on this community asset, as opposed to this is an asset that has not actually been distributed and awarded to either party. And if the court looks at the minute entry, it's the trial court's language is, I had intended to award this to husband, but I am not going to now award it to him until he comes current on a spousal maintenance. I think that meant it was still a community asset, and I don't think it's fair to suggest that we are needlessly prolonging the litigation when we raise issues regarding the value of that asset later. I see that my time is up. Thank you.
Thank you, counsel. We appreciate the arguments here this morning. We're going to take this matter under advisement. We will issue a written decision in due course. With that, we are adjourned.